Now, I've just spent some time outlining the key steps in a fair procedure, but I want to re-emphasise that any fair employer will always see redundancy as a last resort, and that's something the employment tribunals are particularly keen on. So right at the outset of the process and through as it unfolds, employers will need to be creative in seeing whether there's any way of either avoiding redundancies or mitigating them. One common technique is to ask for volunteers for redundancy to avoid compulsory redundancies. That has pros and cons, but if you do ask for volunteers, it's important to appreciate that they will be entitled to the same redundancy pay as people who are made compulsory redundant. Another way of dealing with things is to invite employees to consider reducing their hours or even reducing their pay. Both those steps will need the employee's agreement, because if you unilaterally reduce hours or reduce pay, you'll be in breach of contract and you'll give the employee the right to claim unfair dismissal, so you don't want that. But what I want to spend a bit more time on at this section of the talk is looking at alternative employment, because that is quite tricky. An employer, when implementing a fair redundancy program, is expected to consider right through the process whether there are other jobs in the organisation to which the redundant or potentially redundant employees can be deployed. And that continues even after you've decided on the redundancies and issued redundancy notices. For example, if someone is working a 12-week notice period, it may well be that circumstances change during that period. What do you do if a suitable job comes up during that 12-week period? Well, the answer is you'll be expected to offer that job if the redundant employee is suitable, offer that job to the employee and give them a chance to avoid redundancy. Now, you don't have to withdraw the redundancy notice, you have to simply offer to re-engage the employee at the end of the redundancy notice in a new job. And if you do that, then there's a statutory 4-week trial period that applies that enables both you and the employee to test out the new job to see if it's suitable. If the job isn't suitable for good reasons, then broadly speaking, the employee will keep the original redundancy payment. If, on the other hand, the employee terminates the trial period unreasonably, then there's a possibility that the employee may lose entitlement to redundancy payment.